The application and the responses revolve around the above provisions. For clarity and as a way of distinction, the last amendment of the present section 87A was in 2012. This was way after the effective date of the Constitution. Hence, any alteration, if intended, would have been introduced at the subsequent amendment. Testing Section 210 under the present position, it is instructive and unequivocal that Section 210 of the Criminal Procedure Code only relates to circumstances after the close of the prosecution's case, which is not the case herein. Section 204, on the other hand, relates to withdrawal of complaint by the complainant. As is the practice, such withdrawal is only made on oath, which is not the case herein. What then is the recourse under the circumstance? As pointed out, the provisions the prosecution sought to employ withdrawal of the case herein under Section 87A of the Criminal Procedure Code. The end result is not in contest that it results, if allowed, to a discharge and does not bar subsequent charge of the accused person on account of the same fact. This is not a termination of a case per se. The case would remain alive and at the whim or discretion of reinstitution by the prosecution. The case shall remain hanging on the neck of the accused person. The accused person shall live in perpetual fear of rearrest and reinstitution of the charges on similar facts. In deciding whether or not to allow the application, the central principle to be borne in mind is whether the threshold have been met. In exercising discretion under Section 87A of the CPC, the court must satisfy itself that the threshold for grant of such order is demonstrated. In this case, the prosecution has outlined 4 grounds as espoused above. The ground revolves on insufficiency of evidence to sustain the charge. As it stands, according to the prosecution, the charges as they are bare and unsupported. In the absence of the evidence, they find difficulty in procuring. 9 witnesses have testified as listed in the 4. It is upon reviewing the evidence recorded so far that the prosecution deemed it necessary to discontinue the prosecution of the accused for insufficiency of evidence under Section 87A of the CPC. The defense, on their part, as much as they do not object to the termination of the charges, or the view that to bring closure to the matter, then acquittal would suffice. This charge, according to the defense, is prone to misuse, an act that would infringe to the accused person's right guaranteed under Article 50. I agree with the defense that discontinuance of the matter under Section 87A of the CPC would not bring closure to the matter, as it shall remain an active sword that can be swayed by the prosecution at their whim. The prosecution, on their part, maintained that it is not in possession of sufficient evidence capable of sustaining the charge, hence deem it proper to discontinue the same at this stage under Section 87A of the Criminal Procedure Code. The prosecution cites its inability to avail crucial witnesses to prove the charge, hence, as it stands, the charges against the accused person are not supported. The prosecution is silent on its potency to reinstitute the charges should the application be allowed. Taking a cue from Mr. Biko's submissions on proper utilization of the court's time, of what use would be to the court to sustain a charge admittedly not supported? What would be the party's cost implication of attending to a trial whose evidentiary portent is known and admitted by the prosecution? It is a not trial in my view, and sustainable trial, and sustaining the same would be by extension entertaining the abuse of the process of the court. In as much as I sympathize with the accused persons who have been subjected to this admittedly unnecessary trial for over 18 months, the only available recourse would be to allow termination of the case under Section 87A of the Criminal Procedure Code. This court's ruling is explicit as to the admission by the prosecution of its grounds for termination of the case. That is the account of lack of evidence. Admission that the prosecution does not possess sufficient evidence to sustain the charge, to sustain any of the charge against any of the accused persons. In the end, I allow the prosecution's application to withdraw the charge under Section 87A of the CPC. Each accused person is discharged accordingly, and I direct that the cash bail deposited by each of the accused persons in court be refunded to the respective depositors. Those are the orders of this court.
Mumeona mahakama imetuliliza. Kwa sababu sasa hakukuwa na kesi tulikuwa naye. Tunashukuru Mwenyezi Mungu kwa sababu ya hiyo haki tumepata. Tunashukuru mahakama, tunashukuru mawakili wote ambao walifanya hiyo kazi na nyinyi pia. Na tunasema Mungu awabariki, awape nguvu tupate kuendelea kila siku. Ile ningewahimiza ni kwamba tunapoendelea tuweke nchi amani, tuzingatie amani kila area ili tuendelee na tukijua kwamba wale ambao walituweka katika hii makesi pia wao wako makesi, si ndio? Ndio hivi ndio kana ne atotai karatiguo ndio tuchamania kabiroi na
Gomothe tutiakima goko turi ando free. The state has been unable to sustain its fabricated case. The state has miserably failed to sustain its lies. The state has been unable to sustain its rumor, and the state has been unable to sustain the charges and the cause. It is to that effect, therefore, that today we are free. Today we are free. It is on that reason we are saying freedom is here. Freedom is here. Freedom is here. Freedom is here. Free at last. 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 Freedom is here. Freedom is here. Next time when the state begins or decides to initiate such kind of fabricated cases, they must be ready to meet equal and opposite force. So I want to thank all the people we have been working with, my fellow advocates, our clients, and most importantly the court. This is one of the most progressive and open-minded court.
Yes.
The magistrate was very fair to everybody. The citizens and the gallery was equally well disciplined, and we all thank everybody. Na tunasema siku ya leo tumepata uhuru wetu. Tumepata nini? 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 Uhuru wetu. na ndio maana yake tumekuja hapa kusema ni asante kwa mahakama na kwa wajitayarishe, wajua watapambana na sisi pia siku nyingine. Sijui
aterere maondo maya ne magoka guthira ne turaiguithania ne tuona ore igoti riuga umuthe that akukwa na kesi yenye chama na konayo ya kujibu, na tunajua haya mambo yote ambayo yanaendelea ni mambo ya kisiasa, kwa sababu ni mambo baseless ambayo haifai ikwe kituandama, na sisi sote tutaungana pamoja, kwa sababu lile lengo ambayo tuko nayo kwa nchi hii ni kutembea kama kitu kimoja. Uhuru umekuja ama haijakuja? Tumefurahia ama tujafurahia?
Sasa Mungu ametusaidia. Kiongozi tuko naye ama tuko naye? Kiongozi tuko naye. Kana ni tutafika. Tuko Jordan. Tuko Jordan. Na tutavuka. Kiongozi wetu ni nani? Kiongozi wetu ni nani? Sasa kazi inaanza.